Good afternoon, everyone, and welcome to this webinar about non-compete clauses and the impact that they have on workers, and about the FTC's proposal to prohibit virtually all non-competes. My name is Terry Gerstein. I am a senior fellow at the Economic Policy Institute, and I direct the project on state and local enforcement at the Harvard Center for Labor and a Just Economy. The Economic Policy Institute, EPI, which is hosting this webinar, is a nonprofit, nonpartisan think tank created in 1986 to include the needs of low and middle income workers in economic policy discussions. So I'm going to start out. We have a really exciting lineup for everyone today. A few housekeeping issues first. One is that this webinar is being recorded. If you have questions, please put them in the Q&A and we'll be sure to try to answer them. And then also, as Elizabeth Wilkins from the Federal Trade Commission is participating in this webinar and all of the comments in it and questions will be part of the comment record that are included in relation to the notice of proposed rulemaking. So I'm going to share with you the people who are going to be speaking today, and then we'll jump right in. We have Kevin Borowski, who is a worker. He worked for a residential management company in Minneapolis, and he recently had a situation in which he had signed a non-compete, and it created some real challenges for him. So he's going to talk to us about his experience. We have Evan Starr, who is an associate professor of management and organization at the University of Maryland Robert Smith School of Business. And Evan has done an enormous amount of research on non-competes and is really, perhaps the preeminent expert nationally on non-competes. He's the person I always turn to when I have questions about them. And we have Elizabeth Wilkins, who is the director of the Office of Policy Planning at the Federal Trade Commission and was one of the key people involved in the FTC's proposed rule. So we're going to start out with Kevin sharing his story with us, and then a few questions, and then we'll jump right into a conversation with Evan and Elizabeth. So Kevin, I'll turn it over to you. If you could I know you've prepared some thoughts and sharing your story about what happened to you in relation to a non-compete.
Yes. Hello, everyone. My name is Kevin Borowski. For most of the last decade, my wife and I have been caretakers in a condo in downtown Minneapolis, working for First Service Residential. My wife and I live in the building and do work to make sure everything is running okay and clean and comfortable for the residents. As caretakers, we responded to resident emergencies around the clock, maintain the building pool, clean the hallways and other common areas. You may have seen my story in the news about my public push to form a union. 2 years ago, I led a class action lawsuit against my employer for wage theft, and we won a $225,000 settlement for over 100 workers. Since then, I have been a vocal supporter of the ongoing union organizing effort. I believe that First Service fired me and my wife because of my organizing work. The firing is especially striking because First Service never previously disciplined me or my wife. In addition to firing me and my wife, First Service has forced us to leave our home. We are fighting this apparent retaliation, but I am here today to talk about the salt in the wound that came with this already frustrating and scary event. Caretakers and desk attendants at my company had been forced to sign non-compete agreements before we will be hired. This agreement prohibits us from doing similar work in Minnesota for a year after leaving the company. The company reminded us of this when firing us and forcing us from our home of many years. In their email to us, they wrote, "At the start of your employment, you may have signed a confidentially non-compete document. The provisions of this agreement survive your employment ending date, so please be aware of the items, processes, and contact information that you should continue to hold confidential." In other words, First Service fired us, forced us from our home. and told us that we cannot earn a living in our field for the next year in Minnesota. First Service Residential is the largest property management company in North America. They have operations in 24 states. It also has subsidiaries or affiliates such as Planned Companies, Paul Davis Painting, and CertaPro Painters. The company employs hundreds in Minnesota and thousands nationwide. The fact that so many workers sign these non-compete agreements would be laughable if it wasn't so common. It forces workers to stay at companies instead of taking better offers and holds down people's chance to make a living when they leave. It means if you are like myself and my wife and have done something for a decade and you leave your company for whatever reason, you can't do the work you are most skilled at. It's another way corporations are rigging the system to make sure workers can't seek out better pay and conditions. I am happy to say that after my story was in multiple media outlets, my company reached out to let me know they were revoking the non-compete agreement for me. But it shouldn't take a situation like mine and considerable media attention to address the issue. We know that First Service affiliate company, Planned Companies, which provides building services in New York and New Jersey, still includes no hire agreements with its clients, which denies workers their rights to seek the best possible job. Planned Companies' anti-competitive contracts are the subject of an FTC complaint filed by our sister local union, SEIU Local 32BJ. I am thankful you are taking on this issue at a national level. Thank you for being a leader and standing up for workers and their families.
Thank you, Kevin. Thank you so much for sharing that experience with us, which I know from our prior conversation is just like a really, really hard situation to find yourself in. So thank you for, in the midst of everything that's going on, sharing your story with everyone and helping people understand how non-competes affect people. So I have just a couple of questions for you. One initial question is, do you remember signing the non-compete? And can you tell us a little bit about that process and your experience in signing it?
Well, sure. I do absolutely remember signing it. Although at the time we were trying to gain employment and we were excited to have that employment. And a condition of that was signing a lot of papers. So it was rather overwhelming. So when it came to the non-compete, it was just like, whatever, let's sign it so we can go to work. We just want to go to work.
Were you given any option not to sign it, or was it just like, this is the paperwork that you have to sign if you want to work here?
No, we weren't given an option. And actually, reflecting back on it, I realized that this document is like 5 or 6 pages long, and we weren't given any time to read it. It was just sign it, and then it was stuffed in a folder, and it was handed to us after our 45 minutes or whatever it was we spent going over everything you need to go over when you with HR when you work for a company and initially get hired.
And can you just give us sort of the 50,000 foot view of the kind of work that you did, because people might be wondering, like, well, were there trade secrets or confidential information? But your work really was not of that type. So can you share with everyone the kind of work that you were doing, just the big picture of it?
Yeah, the big picture is condominiums are similar to apartments, except the big difference is condominiums are individually privately owned. Part of condominiums is, in order to be condominiums, you have to have an association, and the association is just it's the governing association that covers all of the common areas and mechanicals in the place. So our job really is to clean and take care of all the common space in the condominium, help the residents with whatever they, be helpful, be nice, but make sure that the common area is all clean and taken care of. And if something's broken, fix it or call in a vendor and have it fixed.
And you did mention that after your story got some news coverage that you were released from the non-compete. If you had not been released from the non-compete, what kind of situation do you imagine you'd be in right now?
Well, we'd be in a lot of trouble. I mean, first and foremost, just the situation we're put in simply because we're living on site, and we were asked to leave within 40 days. So that kind of put us in a bind, but then not being able to reach out and actually go to work as a caretaker in another building. There's all kinds of caretaker jobs that are not first service jobs. We weren't able to do that. In fact, it might have been helpful since we both lost our jobs and were unable to actually rent because nobody wanted to rent to us. Actually, I think management companies that do apartment rentals are held by a certain standard and they just can't rent to somebody who doesn't have a job. So if we knew from the very beginning that we were released, at the beginning of our 40 days, we would have had time to take other caretaker jobs and moved in. As it turned out, we didn't have time to do that, but fortunately, because of the coverage, people have stepped up with job offers and housing, and we're now in a new place. We're in a good place.
And one question that has just come from the audience is whether the company offered any kind of training when you started that would suggest that you would be indebted to them in some way.
Absolutely not. There is no training. We brought our own skills in, and we put the skills that we already had to use and made the place great.
And one final question, which is, what advice do you have for workers who are currently dealing with a non-compete?
Well, I think first and foremost, these non-competes have to be ended. It's just a joke. I get it at some, scientific top end level, national security, maybe there's something there. I'm talking about the millions and millions of people like myself. Unfortunately, since these companies basically weaponize these non-competes and force you to sign them, I say, if you want the job, sign it. I mean, that's all you can do. And, it's all you can do until companies are forced to end the non-competes. You're just stuck with signing it. You're just going to have to.
Well, thank you so much for sharing your story and for answering these questions. And as we get into the discussion, you can let us know if there's points where you want to jump in as well. And I'll turn over to Evan now. I have an initial question for Evan that maybe I should have asked at the very outset, which is just, can you tell us what are non-competes and how common are they?
Thanks so much, Terry. Yeah. So a non-compete agreement is typically a term in an employment agreement, or it could be in an employee handbook as well, which says that after the job ends, for any reason, the worker typically can't get a job in that area and with a competing employer, typically for a year or two. Sometimes there are restrictions on geography, which could be the state, could be a few miles from the place of work, but it could be the whole United States, or in some cases there are no geographic restrictions. And so the typical non-compete would prevent a worker, like in Kevin's case, from working for a year or two in the local area in their industry. We tend to think of non-compete agreements as things executives would sign, and indeed executives are the most likely to sign them. Between 60 and 80% of executives do have non-compete agreements, but that's just the small fraction. In fact, most workers who have non-competes are more like Kevin. The typical worker with a non-compete is an hourly paid worker making at the median about $14 an hour.
And Elizabeth, we'll turn it over to you now just to frame the discussion. The big newsworthy thing that has happened in the last couple of months on this is that the FTC proposed what is virtually a ban on virtually all non-competes. And so can you just tell us a little bit about the FTC proposed rule?
Thanks, Terry. Yes, in early January, the Federal Trade Commission proposed a rule that would prohibit non-compete clauses between employers and workers. That means a couple of things. In the proposal, we would prohibit an employer from entering into a non-compete with a worker, enforcing a non-compete, continuing to require workers to sign an existing or template employment agreement with such a non-compete, or to tell a worker that they are bound by a non-compete. The other thing it does is it requires affirmatively that employers notify their workers that they're no longer bound by these contract terms. And then two other interesting features, I think, well, there are many, but two particularly salient features of our proposal. One is that there's a broad definition of worker, which includes employees, but also independent contractors, externs, interns, volunteers, apprentices, and business owners who provide a service to a client or customer. And it includes workers at all wage levels and job descriptions. The other interesting point to note is that the proposed rule defines non-compete agreement to be fairly broad as well. It includes any contract term that prevents the worker from working somewhere else or starting another business after their employment ends. And it's explicitly a functional definition. So it doesn't have to be named in the contract, a non-compete agreement, or have those specific terms. If there's a contract term that has the same effect as a non-compete, it may be covered by the proposal. So for example, if you have a training repayment agreement, that is an agreement that if you want to leave the company, you have to repay the amount of money that the company invested in you to train you, but the clause says, we trained you for 3 months. But if you want to leave, you owe a training repayment amount of $100,000, something that is completely unreasonably related to the actual training and that functionally prevents, say, an hourly worker from actually paying that. That might be a non-compete covered by the rule. There are an inordinate number of other details that I could say about the proposal, but I think those are the most salient points.
Thank you. And Evan, turning back to the research, there was a question in the chat about research and studies, and you have done like a bazillion studies on non-competes. And can you just tell us some of the sort of top line findings about non-competes in terms of how they impact job mobility, worker wages, entrepreneurialism, and so on?
Absolutely. And it's difficult to discuss all of this in a short time frame, so I'll try to be brief. But I think the first place to start is just where we find non-compete agreements. And if you survey workers, you'll tend to find that about 20% of workers say they're bound by a non-compete. If you survey firms, you'll find that 30% of firms use non-compete agreements with all workers. And so non-compete agreements, they do cover an inordinate amount of workers at all levels. If you think about the harms that non-competes do, there's several ways that we've tried to study this. And I think the best ways have been to study state policy shocks, where states have decided to ban non-compete agreements. So for example, in 2008, Oregon learned that non-competes were being used for low-wage workers. And they didn't like that. And so they banned non-compete agreements for hourly workers, which covered about 66% of the population in Oregon. And so what do we observe after that? Well, we can compare Oregon hourly workers to hourly workers in other states. And so we can look at how this ban affects these sorts of workers. And if you do that, what you'll find is that wages tend to grow about 5% several years after the ban takes place. Well, you'll find that job-to-job mobility rises, especially within industry mobility. And so, it suggests that non-compete agreements were holding down workers' wages. They were preventing them from taking better jobs. There's a similar policy experiment we saw in Hawaii. In 2015, Hawaii banned non-compete agreements only for tech workers. They still have low-wage non-competes in Hawaii, but you can't have them if you're in the tech industry. And that sets up a very nice natural experiment where you can compare Hawaii tech workers to other workers within Hawaii, or you can compare it to other tech workers in other states. And if you do that, you'll find the same thing as in the Oregon study, which is that tech workers in Hawaii become more mobile after the ban takes place. Their mobility increased by about 11%, and the wages increased by about 4%. And so I think that the evidence at this point suggests that when you ban non-compete agreements, workers tend to benefit. There's several other studies which are out there which document that non-compete agreements also spur entrepreneurship. And this is important because non-compete agreements are not just restraints on employees moving from firm A to firm B, but also on starting a new firm as well. And so this is a really important issue, because if you think about engines of growth like Silicon Valley, in California, they banned non-compete agreements in 1872. And some people think that that was an important conduit, an important part of the rise of Silicon Valley, because workers were able to start new companies. They were able to hire workers to help grow in areas where they wanted to grow. And so there's a variety of research documenting how enforcing non-compete agreements clamps down on dynamism and hurts new firms, hurts workers. I want to say one more thing here, which is that when we tend to think about non-compete agreements, we often get stuck in thinking about the individual employment relationship, right? A given worker in a given firm. And the way the courts have handled this historically is by taking it on a case-by-case basis. So if Kevin's non-compete went to a court, the court would say, is this reasonable? Is there some legitimate interest it's protecting? Is the worker harmed? Is the public harmed? And they would do this case-by-case analysis. And what that approach misses is it misses two things. One is that non-compete agreements can have effects in the aggregate. If you think about a recent, if you think about an industry where non-compete agreements cover most workers, right? Think about an industry where everybody's covered, just as an extreme example. Who is going to be able to make you a job offer in that industry? Who is going to start a new firm, right? What's going to happen to that particular industry? And the answer is it's going to stagnate. There's going to be no entrepreneurship. There's going to be no job offers. Wages are going to stagnate. Job offers are going to stagnate. And so the result is we've harmed competition, but not by the act of any one person. It's everybody acting collectively. And so we have a recent paper which documents exactly that when you look at nationally representative data on the use of non-compete agreements.
And Evan, is Kevin's story about not having any negotiation about his non-compete? What does the research show about, because some people might say, well, if a worker's willing to sign one and they negotiate it, like who is the state to intervene with a contract, right? And so there's a lot of problems with that argument, but just, a research question, what does the data show about that?
Yeah, as a baseline, just to set people's expectations, only about 1/3 of workers negotiate over their wages, right? And so it may not be surprising once you learn that to know that a far smaller fraction report negotiating over their non-compete agreement. That number is just 10%. And of course, this is coming from survey data. And when you ask workers, did you negotiate over this? They want to appear smart. So my guess is that number is probably biased upwards a little bit. Most workers, when they're presented with this document, they want the job, they sign it, and it's typically a take it or leave it offer.
And so another question about the research, I've always argued, and I'm a lawyer and used to work in the New York Attorney General's office, so I have handled non-compete cases in an enforcement context. And from my experience, I've always argued it's really important that they be prohibited and not just made unenforceable, because if the law says you can't enforce them, employers might still stick them in the employment contracts, because what's the worst case scenario is a court says it's void, but there's not really any penalty or deterrent. And so what does the research show? Part of the problem with that is that workers believe that the non-compete, even if the law says it's unenforceable, workers think it is valid because, you assume that what's in your employment contract is actually like according to the law and permissible under the law. What does the research show about that, about workers' subjective beliefs about non-compete enforceability?
Thanks so much, Terry. It's a great question. And let me just preface this answer by saying that one of the most striking findings about the use of non-compete agreements is that they appear in states which invalidated them hundreds of years ago. If you look in California, every study of executives, of physicians, of the average worker finds non-compete agreements in California, even though they passed a section 1600 in 1872, which prohibited which made unenforceable non-compete agreements. And so firms are still using them in California employment contracts. And so I have some research documenting two things. One is that a non-compete for a worker in California has similar effects to a non-compete for a worker in a state that actually might enforce that agreement. And that is that the chilling effect of the non-compete agreement is what really matters for most workers here, because they can't finance a lawsuit to get out of even a frivolous non-compete agreement. And we're not talking about the executives here, we're talking about the typical worker. The second thing to note is that when you ask workers, what do you think would happen if this made it to a court? And what workers will tell you is that they think that when they sign a contract, they put their name on the dotted line with their signature. They tend to believe that that contract will be upheld, even if they happen to be in a state like California that wouldn't actually uphold that contract. And so again, most of the action on non-compete agreements is happening outside of the courtroom, where a worker in California might even be trying to take a job and they get a threatening letter. And that leads them to either stop searching or prevent them from even taking a job in the first place.
So let's move to, let's bring Elizabeth into the conversation. Elizabeth, can you talk about why the FTC got involved in this area?
Absolutely, Terry. And I'm so glad that Evan made a few of the points that he did, because they're a nice tee up for some of the reasons why the FTC is concerned from a competition standpoint about non-competes. The agency has been studying non-competes for years now. We started having workshops about 4 years ago to explore the evidence surrounding non-competes, which we've heard a little bit about today already, and our legal authority to address them. We've now had, I think, 3 open comment dockets where we solicited information from the public about them. And you can see why a competition agency would want to explore this. You know, it is right in the name that these are restraints of trade that we should be worried about. We are an agency that promotes fair competition, and these are agreements that prevent competition by their terms. So this is something that the agency has been interested in for a long time. They've actually been, non-competes have been the subject of antitrust scrutiny for at least 100 years. But as Evan mentioned, the kind of one of the most important features of the ways in which courts have scrutinized these is that they've been on a case-by-case individual basis. Courts have looked at whether or not an individual non-compete is reasonable as between the parties. And the reason that the agency started really looking into this in the last 5 years or so is because the economic literature around the industry and economy-wide effects of these non-competes has really kind of blossomed in the last 2 decades. Part of that is because there's been some really interesting state experimentation. Evan has mentioned that some of these state-level law changes have created the opportunity for economists to study in a quasi-natural experiment sort of way what happens when you increase or reduce the enforceability of non-competes, and we can kind of directly study the wage impacts or the innovation impacts. And so this is sort of what has led the agency to say what tools might we have that are different from a sort of individual case-by-case enforcement mechanism to look at non-competes. And this is one of the reasons that rulemaking has become more of an attractive option, because we now have a body of economic evidence suggesting on an industry or economy-wide basis that these have pretty significant effects on competition, both in labor markets and also with respect to innovation, business dynamism, business formation in product markets as well. The other thing I'd note is the agency has been really focused on developing out exactly what it means for us to have the authority to enforce against what we call unfair methods of competition. This is an authority that's unique to the Federal Trade Commission, that is broader than the traditional antitrust laws. And one of the things that it allows us to do is look at conduct that has a competitive effect in the aggregate. So the combination of looking at that unfair methods of competition authority and looking at conduct that may violate that in the aggregate, and looking at rulemaking as a tool and our ability to address industry or economy-wide harm, in addition to this burgeoning economic literature, made the time right for the agency to think seriously about proposing a rule like this.
And what was the reason that the FTC proposed a ban on virtually all non-competes instead of just banning them for low-wage workers, for example?
We take very seriously and long and hard our obligation to put forward a considered policy proposal. And what we found, honestly, was that there were pretty significant effects on competition across the wage scale and across job descriptions. But they look a little different for different categories of workers. So for hourly workers, we've talked a little bit, Kevin, about your situation. You know, in the sort of parlance of competition law, these look like what we call naked restraints. They're restraints on competition that have no justification. You know, we're not protecting trade secrets here. We're not protecting a training investment. They are just restraints on competition that can't be justified. In addition, under our sort of unfair methods of competition framework, they look pretty coercive and exploitative as well. As we've talked about, these are often signed without full understanding or knowledge of what they mean, without the ability to meaningfully negotiate them, you know, which create enormous pressure and difficulty at the moment that the worker is trying to leave to get a new job. So for low-wage workers, highly coercive and exploitative, and virtually no justification from a kind of competition law standpoint. For some higher wage workers, and our proposal acknowledges this, there may be some reasonable reasons why employers might want to use non-competes to protect information, to protect investments, et cetera. But we find pretty significant harms to competition at the same time. So first, the labor market effects of depressing wages we see basically across the board. It doesn't matter if you are an hourly wage caretaker or a software engineer. If there's not kind of good labor market mobility at your level, your wages may still be depressed. There's even some evidence that CEO pay is depressed because of non-compete. So we see the kind of anti-competitive labor market effects across the board. And then on the product market side, to the degree that we're worried about innovation, it's actually the knowledge workers and the executives that we may be even more worried about. Those are the workers who, if they go to another company, they have knowledge that isn't the confidential knowledge that employers want to kind of keep confidential, but is just sort of the learning, the cross-pollination, et cetera, that the recombination of experience might lead to new innovation. That's like kind of what we see in Silicon Valley. And then the CEOs might be the ones who are most likely to go out and start a new business and to actually create competitors. So we see really significant harms to competition the higher we go on the wage scale. Lastly, we took a look at the justifications that we think that employers might put forward for workers like this. And we find that there are other less restrictive ways for them to protect their legitimate interests. So employers can use non-solicitation agreements if they don't want you to take your client list with you. They can use non-disclosure agreements if they don't want you to take confidential information with you. And at the end of the day, probably most importantly, if they really want you to stay, they can make your pay and working conditions better. They can compete fairly for your labor. Given all of the harms, given that there are other means for employers to meet their needs, we felt that a across-the-board ban was the right proposal to make.
So Evan, what does the research show about this in terms of non-competes applying to higher paid workers and the value of non-competes to employers and their need to have, you know, employers sometimes say that they need to have non-competes for higher paid workers. I know you just did a really, really interesting study on data from Washington State. So can you tell us about the Washington study and also just tell us in general about, you know, share your thoughts about non-competes for executives or higher level workers?
Absolutely, happy to. And thanks, Elizabeth, for teeing that up so nicely. You know, the issue of executives gets brought up all the time, top management workers, you know, highly paid workers. And I think that's the FTC NPRM is very clear that there's a different justification for those types of workers. And so I want to talk about two studies briefly. One is this study where what we're trying to figure out is, do firms actually value the ability to enforce non-compete agreements? In other words, we hear lots of talk, right, about the FTC's rule, but the talk is cheap. And so, can we suss out whether firms are willing to put their money where their mouth is? And the way that we did that is we looked at this statute which passed in Washington in 2020. And what it did, it banned non-compete agreements for workers making under $100,000. Now, that may seem like not an enormous amount of money, but that's actually about the 80th percentile of the earnings distribution in Washington. And so the idea of our study is pretty straightforward. It's that if you take a worker who's making $99,000, in 2020, there's no chance that the firm could enforce that worker's non-compete agreement. And the reason is because they're below the statutory threshold. But of course, the firm could have a chance at enforcing that worker's non-compete agreement if they were to give that worker a small raise. And they would likely do that if they received any benefits from exceeding that threshold and then being able to enforce that worker's non-compete agreement. And so the test is pretty simple. If firms do value the ability to enforce workers' non-compete agreements at 100,000, then what we should see in the data is after 2020 comes into play, we should see more workers at $100,000 or just above, and fewer workers at $99,000 or just below. And so that's the test. And so what we have is the near universe of workers in Washington in our data from proprietary data from the state of Washington. And all we do is we look to see if there's more workers at or above $100,000 after 2020 relative to before. And the answer is that we don't see any evidence of this sort of valuation. We don't see any evidence that firms are giving workers raises to get them to this threshold. And that's true in manufacturing. It's true in professional, scientific, and technical services. It's true across the board, across every industry. The second thing that you might wonder is like, what's going on here? So what I did is I joined the Washington Bar Association, which you can too for $30. And we surveyed employment attorneys in Washington to ask what was going on. Are you aware of this law? Were you telling employers about the threshold? And what they told us is that they estimated that in 2022, that only about 10% of their clients would give raises to just below threshold employees to get them to the threshold. And when we asked them why not, they told us that they rarely have to go to a court to enforce these things and that they have other tools, exactly like Elizabeth was just saying. The second thing I want to say about, Terry, you want to jump in about executives here real quick? Okay,
go ahead.
So the second thing I want to say about executives is that executives are tricky because in some sense they hold the keys to the kingdom, right? They also can deliver tremendous value to the company. And so, that is a point that you'll hear over and over again from potential business groups. But I think it's really important to just think about the harm that non-competes can have even for executives. And so I just want to summarize briefly a recent paper by Leon Shi, which is forthcoming in a top economics journal, which studies the market for executives. And the argument here is that executives of anybody are likely more rational. They have attorneys negotiating their employment contracts for them, right? And so if anybody's going to benefit from a non-compete agreement, it's probably going to be an executive. But what she considers is the following case. What if the executive is actually not a very good fit at this company? What if there's another executive out there that would be a much better fit, right? What if the executive that we're talking about at firm A, what if they were a better fit at firm B? And basically the problem is that non-compete agreements can lock workers into your firm, even though they might be better fits elsewhere. And so we end up with this misallocation of workers, and workers would be able to be much more productive elsewhere, but they can't get there. And so, what she does is builds a model that trades off these two dimensions: a perfectly rational agent bargaining over a non-compete agreement versus the costs from this misallocation in the market for executives. And her finding is that the misallocation channel is so strong so as to justify a near complete ban on non-competes for executives. And if that's true for executives, then I think it's hard to fathom that anything else is true for the typical worker in America.
Thanks, Evan. And we have a question from one of the audience members, which is a question that I was going to ask Elizabeth. I think they've asked it a little bit more diplomatically than I might have. The question is basically, this rule has been proposed, and obviously if a rule is ultimately finalized, there's likely to be a court challenge. And so how does that possibility, and given that the federal judiciary is what it is, the Supreme Court is what it is, how does that possibility weigh into the FTC's thinking in analyzing and working on this issue?
Thanks, Terry, and thanks, anonymous audience member, for that one. Listen, the FTC statute is very clear. The FTC Act gives us the authority and the obligation to police unfair methods of competition. The statute is very clear that we have the authority to make rules with respect to unfair methods of competition. And so here we are. And the agency has a history of doing so. And in fact, has done many competition rules in the past. I think the way that I personally think about this is, given that this is the mandate that Congress gave us to protect the American public from unfair methods of competition, and given that these are the tools that Congress gave us, and given the magnitude of the harm that we at least preliminarily find in this proposal, we really have an obligation, I think, to be creative in thinking about applying those tools to the challenges at hand. Our task right now is to ensure that we have the most robust comment period that we can. And once we have the opportunity to review those comments, to take them seriously, to put forward the best final rule that we can, and that's what we're focused on.
And now that you've mentioned comments, can you talk to people about what is the comment process for people who aren't familiar with it? What's a comment period? What are comments for? What's the difference between a proposed and a final rule? And does someone actually read all of those comments? So can you just walk us through the administrative commenting process a bit?
I would be delighted to talk about the comment process. So one of the extraordinary benefits of rulemaking is the sort of participatory role for the public, which is in line with our traditions both of democracy and of due process. In order for an agency to make a rule that has the force of law, we have to let you, the public, tell us what you think about it, and then we have to seriously consider those comments. So specifically with respect to what the FTC is doing, on January 5th, we put out, I think it was 5th, our proposed rule. The rule itself is very short. It's about 5 pages. The supporting material, take it to about 200. It's, I think, totally scintillating reading, so I commend it to everyone. It is now publicly available, and the Federal Register, regulations.gov, where you can search for the non-compete rulemaking, is the place where you can submit comments. We have a 60-day comment period through March 20th, where anyone can go online and submit a comment. It doesn't have to be scholarly. It doesn't have to be long. It can be anonymous. It can be anything from a one-line personal experience to a 100-page research document complete with econometrics. Anything that the public wants us to know and consider as we are thinking about whether and how to propose a final rule. And then we as the agency are obligated to read your comments. That's me and my team. We are putting together the staffing to make sure that we can look at all of the comments that you, the public, send to us to understand all aspects of the issues before we write and propose a final rule. So I really encourage folks to check out regulations.gov. It is reasonably user-friendly. And like I said, if you search for the non-compete rule, you ought to be able to find our comment docket and find pretty clear instructions on how to submit a comment between now and March 20th.
Thank you, Elizabeth. And just to really highlight and emphasize, like, this is the kind of situation where generally employers and business associations, routinely are accustomed to commenting on all kinds of proposals. And this comment process isn't just for this FTC proposal. It's part of the administrative process for any rule that a government agency proposes. And so it is really important that the government hears from ordinary people who are having these experiences as they live their lives, in addition to, business associations and so on. And so it really does not have to be in like highly elevated, lawyerly economist or poetic language. It really can just be someone plain spoken sharing their experience. Evan, in terms of non-competes, what research remains to be done? I feel like you have done so many papers on this, and yet there are all of these natural experiments happening as states are passing laws. So first of all, can you explain what a natural experiment is? And then also like what research do you think remains to be done in this issue?
Yeah, thanks so much. It's such a great question. And, we have seen an explosion of research in the last 20 years on non-competes. There are a few areas that I think we need some, that I would love to see more work in. These natural experiments where states are passing these things, these are helpful because they help us sort out causation from correlation. And let me just give you an example of why that is. If you were to look at data on workers with non-competes versus workers without non-competes, what you would find is that workers with non-competes tend to have higher earnings. And you would therefore be tempted to conclude the non-compete agreements might benefit workers by increasing their earnings. But this is just correlation. Non-compete agreements do tend to be more common in technical jobs, higher skilled jobs. And so, of course, it's like comparing an executive to a non-executive. The executive is going to make more money. It may have very little to do with the non-compete agreement. And so the way that researchers have got around this is by studying these state policy shocks. And so that's one problem here. And just to make the point about causation and correlation even more clear, suppose you wanted to know if going to the hospital made people sicker or healthier. And if what you had is data on the health of people who went to the hospital and people who didn't go to the hospital, you would find that the people who went to the hospital are sicker than the people who did not go to the hospital. You wouldn't then conclude that hospitals make people sick, right? What you need to do is figure out what would have happened to that individual who chose to go to the hospital. What would have happened to them if they did not go to the hospital? That is the challenge we face with non-competes. We need to figure out what's going to happen to a worker who has a non-compete. What would their life be like if they didn't have a non-compete? And that's actually really hard. And one of the reasons it's really hard is because non-compete agreements almost always come coupled with all sorts of other restrictions. Whenever you see a non-compete, you're almost always going to see a non-disclosure agreement. You're highly likely to see a non-solicitation agreement for clients and coworkers. And so what this means is that if you're just working with observational data and you compare workers with non-compete agreements versus workers without non-compete agreements, it's actually a very messy comparison. It's not apples to apples, because what you're really comparing is workers with a bundle of restrictions, which you're going to attribute to the non-compete, versus workers with maybe none of those restrictions. And that comparison is not fair. And so some of the most recent evidence we have is that when you take into account all these other restrictions, you get very different estimates from when you just study non-competes alone. So the study that I would like to see done is I would like to see somebody, if there's a company out there who's listening, to randomly start removing non-compete agreements from your contracts, right? Pick some workers, don't offer the non-compete agreements, see what happens to those workers versus other workers, right? That's the experiment that would be really helpful to run here. The second is it'd be great to have more evidence on downstream effects in terms of consumers. How are consumers impacted by this? If new firms aren't getting started, is there less product choice? We have one study on prices in healthcare, but what about other contexts? It seems like enforcing non-compete agreements raises prices because it increases concentration, but we need more evidence, I think, from other sectors to really know the downstream effects a little bit more. So we know a lot, but I do think there are a few avenues where it'd be helpful to know a little bit more.
Great, thank you. And Elizabeth, we've had a couple of questions in the Q&A about state law and how the FTC proposal would impact, there's been a lot of activity in a number of different states on curbing the use of non-competes, some of it really broad, like we already heard about Washington states, or Washington, DC also has prohibited them for workers up to around $150,000. And then some other states have taken action just to curb non-competes for very low wage workers. But how does the FTC proposal interact with state law is question one, which is sort of like just a technical question. And then the more policy question is, what some people might ask, like, isn't this a matter for the states? States are passing their own laws on this, or is this a matter for Congress? critics might say, is this overreach by the FTC? So I'll throw to you both of those, that set of questions.
As to the technical question, so if we were to finalize the proposal as we've proposed it and fully prohibit non-competes between workers and employers, then that's right. Our policy would be for the industries that it applies in, the law of the land rather than state laws that are more permissive. Which is not to say that there isn't a role for state policymaking. So for example, the FTC doesn't have jurisdiction over all industries. There are some industries in which we cannot regulate. So there is a room for state policymaking there. And of course, it takes time for us to do a rulemaking. We haven't finalized a full ban proposal. We don't know what we're going to finalize. So there is room for states to develop out what they think the right policy is for them. And as someone noted, it's reasonable to think that our rule might be challenged. And so it may be a while before our rule would go into effect. So all of those things mean that there is a great amount of room for state policy making, even as we move forward with this proposal. On the flip side, is it appropriate for the FTC to be taking this action? I've already said policing unfair methods of competition is a mandate that we got from Congress. And the tools for rulemaking are also the tools that we got from Congress. So I strongly believe that when we are working within the mandate and tools that Congress gave us, we are doing not only what we should do, but what we are obligated to do. And that is the way that the give and take between Congress and the administrative agencies works. And then there's a couple reasons to think that a nationwide rule is really what's quite appropriate here, given the evidence that we have. So a couple of things. One, I'll just harken back to a conversation, Terry, that you and Evan were having about the chilling effects of non-compete agreements that are in contracts, even where state law prohibits them or renders them unenforceable. If a worker believes that a non-compete agreement binds them, then it has the same effect, whether or not that's the law of the land. And so if we want to see the effects that we desire, both for workers and their opportunities, and also for competition in the market, a nationwide rule that is very clear and very simple and highly salient may be much more effective at sweeping away those chilling effects than a patchwork set of rules might be. Second, the ways that these labor market effects work, they don't stop at the state line. Labor markets can cross state boundaries. So if you think about like externalities and how we're supposed to regulate them in a market, these might be ones that it's hard for a state to fully regulate the competition effects because they spill over across state lines. And then finally, there are things like choice of law provisions in employment law contracts. So for folks who are not familiar with that, an employer might say, okay, here's your contract. And if we get into a dispute, we take that dispute to Delaware. I'm not saying anything bad about Delaware. I love the state of Delaware. I vacationed there as a child, so that's just an example. And so there might be a way to circumvent a state's restrictions against non-compete. So again, if we really think that these are as harmful as the economic literature suggests, then there is good reason to think that a nationwide rule is the right solution.
Thank you, Elizabeth. And we are getting close to our hour being up. We've gotten some fantastic questions in the chat. Given time constraints, we haven't been able to ask all of the questions, but really thank you to everyone for dropping your questions in the chat. And we will be circulating the recording as well as some materials. And some people have asked about research. If you just Google Evan Starr, you'll find many articles. So that's always a good place to start. And the Economic Policy Institute also has some materials about non-competes on the website. And then also, if you look at the FTC's proposed rulemaking, there is the 200-page document that I agree, Elizabeth, I find it scintillating as well. But other people might want to just skim it and not really, savor each and every word. So I could talk about this with all of you for hours and hours, but our time is almost over. So I want to ask each of you if you have some parting thoughts. So why don't we start with you, Evan?
Yeah, thanks so much for the chance to be here. I think it's been fun to follow this debate and to hear the various perspectives. And I think that the point that I hear over and over again made by especially businesses and the Chamber of Commerce is, that the sky will fall if we ban non-compete agreements. And I think that perspective is largely overblown. I think the history of California, even though there are non-competes there, of course, executives are probably aware of that. Tells us that executives have managed that situation for a long time. Companies have thrived in California despite non-competes. There's only one occupation in the whole United States for which non-competes are prohibited, and that's among lawyers. In the 1960s, the American Bar Association made it unethical for lawyers to get into non-compete agreements. And the reason for that is because if an attorney can't practice law because they're sitting out due to a non-compete agreement, then their clients cannot choose their attorney because their attorney's not working. And so the justification for this prohibition on attorney non-compete agreements was based on harm to clients. And I think that if you think about this policy, it is about protecting competition, protecting us against the harms about the mass use of non-compete agreements. And those apply even to executives who, by some estimates, 80% of executives are bound by non-compete agreements. And so once you start thinking about the third-party harms, we get to a situation where, just like in the lawyers who are concerned about clients, a non-compete agreement is a tax on anybody. It's a tax on anybody who wants to hire. It's a tax on you if you want to go start a new company. The harm is felt by many of us. And so I think that those saying that the sky will fall if we ban non-compete agreements, it's probably largely overblown.
Thanks, Evan. And following up on what you were saying about lawyers, that's a piece of it we haven't really discussed as much as sort of, in the medical, in the healthcare field, that it affects patients as well. And there are situations where if you have a non-compete, you can have a doctor that's having to sit out a non-compete. And obviously there's so much need for healthcare, and people, you have whole specialties where all the doctors in a specialty are stuck in one practice. So there are issues of, patient care and healthcare and, other kinds of concerns in addition to the ones that we've talked about today. Elizabeth, how about some closing thoughts from you?
Well, Evan, I think, did an excellent job of closing out on the substance that we're talking about here and what the stakes are. So I will just say one word about government, how we work, and what makes our institutions work. I think this is an instance where, as we saw with the outpouring of individual stories when this proposal went out, non-competes are an issue that affect a broad swath of Americans in a really fundamental way. It affects the ability of people to exercise their economic liberty and to make and earn a living in the way that they choose. And it is something that people feel deeply about. This is, I think, exactly the kind of thing that government agencies should be doing, is trying to figure out, what did Congress say my agency was supposed to do? What are the tools that Congress said my agency has in order to meet that mission? And how does that meet the most pressing issues that Americans are facing in their daily lives? This is an issue that depresses people's wages, limits their opportunity, limits their choice as consumers, limits the innovative products that they have access to. It is really fundamental to the way that we think our economy should work as workers and consumers. It's also, as I said, a rulemaking, which means it's participatory. It means it's a conversation between you, the public, and your government. So I'll just put one more plug in again to make sure that folks spread the word about our comment period, head to regulations.gov, let us know what you think. And it's been a real pleasure to be here to be able to explain a little bit about what the proposal is for people, so that people can know what we're doing and why we're doing it.
Thank you, Elizabeth. And the deadline for comments is March 20th. Is that right?
March 20th. That's right.
Great. Thank you. And Kevin, do you want to share your final thoughts?
Sure. Thanks, Terry. Thanks for having me today. So I know I need to give the quick version of this, but everything that Evan and Elizabeth have been talking about, I mean, great stuff. I love the research, the surveys, the statistics I heard about, but bringing it all in, and I could just the quick version of sharing my story on the effects of the non-compete, just the quick version. Although maybe another time I'd like to even talk about the client or the consumer that Evan had brought up, which in my case would be the residents of the condominiums. But without getting into that, the quick version is I started over 8 years ago at hourly rate, and over time we were given approximately 3 to 4% raises a year. And now fast forward 8 years, the going rate for incoming caretakers is over $20 an hour. My current rate when I was terminated was in the $15 range. So new hires who have the ability to basically like auction off their labor to the highest bidder where they could go anywhere, they end up at first service, but they're at $5 more an hour than the longtime employee. So which another quick version is because of that, it's only because of the non-compete that stopped me from going and taking my labor and bringing it back into the open market and auctioning it off for the highest rate. I couldn't do that unless I took a year off.
Thank you. Thank you, Kevin. And that really illustrates just so powerfully how these non-competes have just a really harmful effect on people's lives. So thank you so much, Elizabeth, Evan, and Kevin, for sharing all of this information and perspectives and stories, and just, you know, sharing so much wisdom and knowledge with all of us about non-competes. And to everyone who joined, thank you so much for joining us in this really interesting conversation. The comment deadline is March 20th, so I hope we'll see a whole rush of comments by the end of the day today. But thank you all for joining us. And again, I'm Terry Gerstein with the Economic Policy Institute, and we hope that you found this useful and informative. Take care, everyone.